All right, ladies and gentlemen. This is it's been a very interesting day for the matter of EDDY Alexandre, United States versus EDDY Alexandre. I've already posted some video about what happened in court today, May 26, 2022. There was some sort of a hearing this morning at the federal courthouse in Manhattan before Judge Catherine Parker. And of course, EDDY Alexandre's lawyer wanted to get their client out of MDC Brooklyn. And this MDC is a federal detention center in Brooklyn. It is not the best place to be. It is a terrible place to be. And I know firsthand how the place looked, and I know it's not a great place to be. So you guys would remember that a couple of years ago, people were so cold, they didn't have heat in the middle of winter. So it's a terrible place to be. But in any event, I'm happy that Emile Bovy, Mr. Alexandre's lawyer, was able to work out a bail condition that actually made it easy for him to get out. So I have a copy of the bail condition that the government agreed to, or the judge agreed to, the magistrate judge. Now, with regard to this new bail condition, remember that before the court asked EDDY Alexandre for a $3 million bond to be secured by 5 responsible person, 2 houses, and 2 cars. Okay. In addition to that, Mr. Alexandre would have to surrender his travel document, passport, and the likes. And his traveling is restricted to the Southern District of New York and Eastern District of New York. So what does that mean? That means that is really restricted to the city of New York. So he can't travel outside of New York City. He could travel within the boundaries of the Eastern District and Southern District. Of course, Manhattan, Brooklyn, part of the Eastern, Long Island also is part of the Federal Eastern District, so he'd be able to travel there. Now, of course, there'll be pretrial supervision. What does that mean, pretrial supervision? Mr. Alexandre would have to check in with pretrial services. Sometimes it's once a week, sometimes it's once a month, sometimes it's twice a week. But in his situation, he's probably going to have to check in probably once a month with pretrial services. Now, the other requirement was that he would have an ankle bracelet, which is kind of a monitoring device that you put on your legs, and they monitor where you are. They'll know, where if you're inside your house or if you're outside your house, they'll be able to monitor. It's a kind of a GPS, and they put on the defendant. So, but this is originally a part of his bail condition. And of course, also the greatest part, I think the biggest part of the bail was the fact that he was asked to hire his own security to protect him from himself. In other words, so that he doesn't escape. Okay, and that was the condition that Mr. Alexandre could not meet. And the reason for it is because first he would have to hire a security company, and then he would have to pay. I mean, it's really expensive. In fact, in the papers that his lawyer filed in court, they argue that it would cost him closely to $100,000 a month just to have security for no reason at all. So that condition was removed. He no longer has to have that. And also, instead of having 2 homes and 2 cars, they added 3 homes. So he would need 3 homeowners to sign to put up this home as part of the bail package in order for him to get out. But the judge also did two things. One, that he now can be one of the 5 people. So in other words, he could sign on his own recognition. He could be one of the 5 people. The other thing is also that he signed an extradition waiver. What is really an extradition waiver, and whether does that make sense legally? Okay, an extradition waiver, okay, is a piece of paper that a defendant would sign to say that I preemptorily give up my right to fight an extradition procedure if I skip town and go to another country. So, for example, let's say that Mr. Alexandre decided that he doesn't want to stand trial in the United States. He's just going to leave, and the hell for everybody, he's gone. As an example, okay? Let's say he goes to Haiti. Of course, they will go there and get him. It wouldn't be any problem to send him back to the United States. Now, let's say, for example, he goes to Cuba or he goes to Venezuela, a country that doesn't necessarily have extradition treaty with the United States. Even though he signed a waiver, that waiver will mean absolutely nothing, because the government would argue, one, that they don't have an extradition treaty. And of course, if he were to do that, then despite the fact that he signed an extradition waiver, he would still fight extradition, and so if the country doesn't have an extradition treaty, there's no basis to even ask for extradition. But I got to tell you that I have to give props to his lawyers. They did a fantastic job. His lawyer, Emil Bovey, is part of a law firm of 139 lawyers in Manhattan. A lot of these lawyers are former prosecutors. They understand what's going on. So it's really, 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 really a good move that he did by hiring these lawyers, because these lawyers, they know what they're doing. Now, here's what I wanna tell people. I don't want you guys to jump the gun. This part of the case is simply allowing Mr. Alexandre, the ability to be home with his family, to be able to consult with his lawyers, to be able to defend himself. Because in prison, it would be hard for him to do it, because of course, when you're in prison, you don't have access, a lot of time you don't have access to people. Of course, telephone is hard to come by, communication is very hard, whether by email, it's very hard. In fact, it is so hard that his lawyers went to see him yesterday, and even though he's at MDC, the lawyer wasn't able to see him because they're saying that the Bureau of Prison, the Bureau said that Mr. Alexandre was in quarantine, so his lawyer wasn't able to see him. So now that he's home, he will be able to consult with his lawyer, he will be able to meet with his lawyer, he will be able to probably figure out with him and his family how best to move forward with the case, how best to defend the case. So that's a great thing, because it actually makes it easy for him now to defend himself. Yeah? So that's a good thing that they were able to agree on that bail package. Now, of course, normally, when somebody gets arrested, the defense lawyer and the prosecutor, they usually, especially at the federal level, they usually get together. They usually say, okay, listen, we're putting a bail package for this person. What can we do? For example, when I was practicing law, I have clients that have been arrested for drug, or clients that have been arrested for counterfeit. I've defended a lot of clients in the Eastern District, in New York. I usually, what I would do once my client is arrested, I would then get in contact with the U.S. Attorney's Office. I would say, hey, listen, guys, what can we do here? What are you guys looking for? And then I would argue with the prosecutor that, hey, we understand you have the case, but my client really, he's willing to defend himself. Let's put something together. So normally it would be a property or something, but not the type of harsh treatment that I see in the Alexandre's case, in terms of requiring him to pay for security to guard him. So that's kind of like, that was really, really harsh. Now, I have to say, and I don't like bashing the federal defenders, because the federal defenders, they do a good job. They, with the little resources that they have, they do a good job. But I feel like when you have a private attorney that you're paying money to defend you. I think that they put more into that defense. So once Alexandre got arrested, if he had a private lawyer, it is more likely than not that he wouldn't spend a week, actually more than a week now, 12, 14 days at MDC, because his lawyer would have obviously negotiated kind of a better bail condition for him. So he didn't get that, and of course, it's not his fault or somebody's fault. It's just that when you get arrested in the federal system, normally, if a person is under investigation, for example, you know you're going to get arrested, you know something is up, you just lawyer up. You know, you lawyer up. You get a lawyer. You say, hey, if anything happens to me, if the government pick me up, I want you to be there for me. I've had clients when I practice law who would call me and say that I'm being investigated and I need you to stand by. If something happened, I want you to be my attorney to represent me. So if he had done that, then he would have avoided the issue of spending that many days in MDC, which is a terrible. But nevertheless, he won that first battle, and this is just the beginning, guys. This is just the beginning, and I want you guys to understand the system. This doesn't go to the merit of the charges against him. Okay, this doesn't prove anything. He doesn't prove Alexandre is guilty. He doesn't prove Alexandre is innocent. This is just the arraignment process. And the defendant certainly has a liberty interest in its own liberty. He wants to be free. And because he's not guilty of anything, he's being allowed the opportunity to stay free until such time he is convicted, if he is convicted. Now, that part of the case is over. Okay, so we can, his family, his friends can be happy that at least they're going to have him and spend some time with him and planning his defense. However, there are a lot more to come. There are a lot more to come, okay? In the next few months, the government is going to continue the investigation. They're going to continue interviewing people. The receiver is going to continue seizing assets, talking to people, find out where assets are. So the receivership can seize those assets, at least can confiscate those assets for now. And as the government do that, the government can prepare their cases. They're going to look at direct witnesses, secondary witnesses. You know, they're going to look at the best way, what the theory of their case would be. Sometimes the government comes with a theory of a case, and then once they realize that they cannot totally prove the theory, they change the theory to something else. They have done it in many cases. They come up and they say, hey, this person is being charged of this, and then they realize, oh, we don't have enough evidence to be able to win a trial, then they change it. In this case, they've charged Alexandre with two criminal charges. One is commodities fraud, which is that he said things that the government says are lies. Mr. Alexandre said, no, those things are not lies, they're true. That's the first charge. The second charge is they're saying that he uses communication devices such as computers to actually tell these lies, which is what we call wire fraud, okay, under federal statute, the wire fraud part, when you use telephone or computer to communicate something that's a lie in the context of doing business, okay? So those are the two charges that he's charged with. So the government obviously is going to try to prove their case beyond a reasonable doubt. They're going to try to do what they can to make sure they have enough evidence. But here's what I've been telling, this is what I want people to know. This type of white collar cases, okay, white collar crime, white collar cases, most of the time, actually all of the time, it's all papers. So the evidence that they're going to present to court, it's all about documents, it's all about papers. And that's why I always tell people, be careful of what you say, be careful of what you write, be careful of how you say it, because what you say, okay, what you write can actually turn around to bite you in the ass. So you have to be careful. So the government's entire case in this matter, it's all about papers. So certainly, they want to prove that EDDY Alexandre lied to his investors. Now, they don't need to bring an investor as a witness to say that, yeah, EDDY Alexandre lied to me. All they have to do is actually show videotape of EDDY Alexandre talking to those investors. Okay? And that would be suffice for them to say what he said isn't true. Now, here's the thing. If I said something to you and you claim it's a lie, right? What is the best defense for me? The best defense for me is to prove to you what I said is not a lie, okay? Now, that is how most people understand it. But in the jurisprudence, in other words, in law, it's different, okay? It's different. I could tell you a lie and not in violation of the law if that lie is material to the thing that the government claim I did wrong. For example, when they say that EDDY Alexandre lied to his his investors, okay? Now, did he lie to the investors because he was trying to hide something from them to benefit him, okay? Or did he tell a lie that doesn't go into the crime? In other words, did he tell a white lie? Did he tell a lie that, you know, nobody cares, nobody believes in anyway, okay? So here's the thing that the way that I think his lawyers are looking at it, right? If I'm defending EDDY Alexandre, first thing I'm going to ask is, okay, first thing the government say he committed commodities fraud. Okay, what is commodities fraud? Basically, they're saying he made misrepresentation in the context of raising money for investment, all right? So what exactly did EDDY Alexandre say that was a lie? What exactly did he say? Did he say to investors he was going to invest their money in cryptocurrency and he didn't? Did he say that he was going to invest them in foreign exchange? He didn't. So the question is, even if the government claimed that he lied about how the money was being invested, if he could show that the money was actually invested and that the payment, that the profit that people got was actually from an investment, then he would have have a great defense, because the government would have said, well, you did say you're going to invest it in the crypto, but you really didn't. Now, as the person in charge, I mean, for example, when you go to Maryland, you invest money. Sometimes they give you choices. They say, okay, what company you want to invest in, so on. But most people who invest money, honestly, they don't even know what company, what stock that they own, what company. Listen, I have investment. I don't know which company necessarily that my money is invested in. Sometimes they may say, okay, you own Microsoft or you own Tesla or whatever it is. I don't know, because that's not what I do. I have somebody who's an expert who does that. So to that extent, EDDY Alexandre may be able to put up a defense if he can show that he actually invests the money, but not necessarily the way he claimed he was going to invest it. Because as an investor, as somebody who's in charge of the company, he can make decision as to whether or not it's good to invest in cryptocurrency or some other companies or some other things. So that is one thing. Now, that is with respect to what we call commodities fraud. Okay. Now that's the first issue. Second issue, the government said that he used telephone because he had a series of Zoom call, Zoom meeting. And there were a lot of people in the Zoom meeting. I think that I listened into one of his Zoom meeting about the presentation, and the government say he uses that Zoom meeting to communicate a fraud in the context of raising money from investors. And the crime is not that he tells a lie. That's not what they're saying. The crime is that he uses electronic devices to tell a lie. So they charge him with a lie, and then they say, well, we know that you lied. I mean, that's what they're saying, but you also use devices to communicate the lie. So that's the wire fraud. That's what they call wire fraud. Now, if he can prove that what he said wasn't a lie, or if he can prove that, yes, I did lie, but that lie was not material to the investment, therefore no one was defrauded because that lie wasn't really important, or that lie did not force anyone to give him money. So in other words, if people give him money because they thought that their money were going to be invested in foreign exchange or crypto, and that was the essence of why they give the money, then the government would have a case. But I can almost see the attorney, if they go to trial, bringing witnesses to say that they invested money with him, but they didn't care whether the money invested in crypto or the money was invested in foreign exchange. They simply invested money with him because they trust him, they like him. Now, that would be a good defense, okay? But there has to be evidence that he actually invested the money. Now, the government case, when you think of it critically, and I haven't done this before, I haven't really attacked the government case at all. And a reason for that, because I wanted to make sure that I wait for everything to come down before I start talking about the strength of the case. The government has a fairly decent case, but it's not an ironclad case. It's a fairly decent case, okay? It's a fairly decent case. Here's what really important in the government case. The government at one point claimed that he lied. He told people he was going to invest in cryptocurrency, but he didn't. But at the same time, the government also said that he did invest money, and $9 million, in which he lost $6 million. So here's the question: is either he took the money, invested in something other than cryptocurrency, lost that money, and then tell anything to the investors. So now the government doesn't necessarily know whether he told the investors or not, because the government would have to demonstrate that the money that he invested, the $9 million, belonged to XY investors, and that he did not tell those XY investors that their money was lost in that particular transaction. So I have no doubt that his attorney would probably do exactly what I'm telling you now, because my job is to try to teach you guys how to look at the case from a legal perspective, from a legal point of view, and try to analyze this how we move forward. So does he have a defense? Yes, he has a defense. And he has a fairly reasonable defense. Now, here's the other interesting thing that I've heard, and I've been talking to people that are very, very close to Eddie, and they've told me that Eddie did in fact invest money in crypto overseas. Now, nobody knows exactly how much money he invested overseas or whose money is invested in crypto overseas. But if the government case is that he took the money to invest in cryptocurrency and he lied to the people, he did not invest it, then if he could show that, hey, I did invest $50 million in Germany or in Geneva or some other country in crypto, then that would actually show evidence of innocence, okay? So this case is not gonna end tomorrow or next year. The government is gonna conduct a lot of investigation. And if the government realizes that the charges they have now, they cannot prove them, they're going to try to find a way to supersede the indictment, okay? The word superseding the indictment means bringing additional or changing to the initial indictment. Now, I know people said that he was arrested in a complaint. What they saw was an affidavit from Joseph Cartman, who's actually the FBI agent that's investigated the case with other FBI agents. But I've reviewed all the complaint and seal indictment, and at this point, that's all they have. That's all they have. And I happen to think that, Eddie certainly would have an opportunity to defend himself. I think that it's not all lost. I think that he certainly can defend himself. So, okay, so the issue now is that probably his next court date may not be until January. Believe it or not, it may not be until January because, quite frankly, there isn't much to do. His lawyers may be able to then file a motion to dismiss the indictment. Now, when I say the motion to dismiss the indictment, what they would say is, they would say, okay, Judge, giving everything that the government says, taking everything in context, it's not a crime. So I don't see that happening. And if they did file a motion to dismiss the indictment, it would be in the context of trying to find out what extra other evidence that the government has, because the judge would have to take what the government say as true, okay? And in other words, for purpose of, deciding on that motion, okay, well, listen, the government says you killed my cat. Well, I'm going to assume that you killed the cat. So if the government can actually prove you killed the cat, then of course. So what's going to happen is most lawyers usually do not file motion to dismiss the indictment because they think it's an exercise in futility. When I was practicing law, I usually don't do it. As a matter of practice, I don't do it unless I feel like I want to pry a little bit into what evidence, if any, the government may have. And then I would go ahead and, and file a motion, knowing that I'm going to lose, but at least I would lose with the understanding that the government would let me know, would open the door. The government cannot, there's no surprises. The government can say, hey, I got you. No, the government has to give to Eddie's attorney every single piece of evidence that they have, including evidence that tend to exculpate him as a defendant. So they got to give everything to it. Now, I don't even want to get into what we call prosecutorial misconduct. In my days, in my time, I've seen a lot of prosecutorial misconduct. I've seen prosecutors, do crazy things, hide evidence, so that they can get they can get a conviction. Now, federal prosecutors, there are very, very few federal prosecutors who would engage in that type of behavior. I can't remember any case of federal prosecutors engaging in that type of behavior, but you never know. Things happen. Sometimes, people take this as a personal matter for them instead of just doing justice. Okay, prosecutors usually do that. When I was a prosecutor, my job was not just to put people in prison. My job was to find out the truth. If you committed a crime, it's the truth. Okay, you go into prison. If you didn't commit the crime, it's not my job. It wasn't my job to try to convict everyone. I wasn't never looking for conviction. That wasn't part of my DNA. It wasn't part of what I was doing. I worked in Brooklyn. People get arrested. I look at the evidence. If the evidence is there, you're going down. If the evidence is not there, I'm not going to create it. I'm not going to make it, because it's not my job. My job is not to do that. So the prosecutor's job is not to create evidence. The prosecutor's job is to look at what's there, what the defendant did, with whom, how, when, where, and then present this case to a jury. So if Alexandre decides to go to trial, there will be a jury of 12 people, mostly from Manhattan, because the Southern District is in Manhattan, mostly from Manhattan. And those 12 people would sit, would sworn in, and they would listen to the evidence. And then they'll decide whether they believe the government or they believe Eddie. So normally, it's always not a good thing to have your client testify. I know I've done a lot of trial in New York State, both at the state level and the federal level. And I can't remember ever asking my client, or actually wanting my client to testify. I often discourage my client to testify because, quite frankly, it is the government burden of proof. It's not me, it's not the client, okay, that have to prove anything. The government has to prove it. But there may be cases where the defense is somewhat intrinsically attached to the defendant testifying. In other words, you may have a situation where only the defendant could explain what happened. And in that case, I feel like in the case, and I'm thinking in that case, because it involves cryptocurrency and because Alexandre said he has a trade secret, now his trade secret may be his defense. Okay, so continue to watch my channel, The Professor. I thank you so much for watching this video. As the case develop, I would bring more to you. I would speak to people. I'll try to speak to his attorney and see if he would give me a statement about the case. Normally, attorneys, don't like to talk about client they are defending. But let's see what happens. So if you haven't subscribed to my channel, please do so. And I want to let you know that there are going to be tons of other very interesting things that I'm going to be talking to you about with respect to a lot of issues. So I want you guys to stay with me, to subscribe, and of course, please share the link with your friend, your family members. And I usually do my videos in English, but and this is really for the Haitian community. This is really the community that I'm speaking to. So if you want me to do something in Creole, just let me know, because I speak Creole very well, better than English, obviously. And I will certainly do videos in Creole about this case. Well, guys, this is it for me today. Thank you for watching. Don't forget to subscribe and send a link to your friend, to your family members. Tell them to subscribe too. Thank you.